So before understanding how to deal with the corrupt police officer who failed to investigate properly, we must understand the procedure for a criminal trial. First, a complainant gives a complaint. Let us assume against 4 persons, 4 accused. Let us assume that the complainant is the daughter-in-law and the 4 accused are husband, father-in-law, mother-in-law and the sister of the husband. Presume it is a 498A complaint or harassment and the complainant filed a complaint. Now police registers the FIR against the 4 accused. Because all the 4 names are written in the complaint, police must register the complaint against the 4 accused. That is the husband, father-in-law, mother-in-law and the sister of the husband. Then he comes to the scene of the crime where the complainant was harassed for dowry, and he investigates with the neighbors. Whosoever witnessed the physical assault, if the physical assault was pleaded in the complaint by the complainant, he will take the statements from the neighbors. Let us presume he took 10 statements from the neighbors. Now remember, in any sort of police investigation, they will not take signature of the witness, because it is very clear in the Evidence Act and the CrPC that if the police officer takes the signature of the witness, then that statement will be thrown in dustbin. They may take signatures illegally, but that they will keep it only to threaten the witness but not to produce in the court. Because if they produce those witnesses' statements which are signed by the witnesses, generally the statement is signed by the police officer or the investigating officer but not by the witness. If the witness signs the statement, it is against the CrPC procedure and the Evidence Act procedure. Then that statement will be thrown in the dustbin. So be rest assured, police will collect the information from the witnesses and write it in his own writing or type it, and he only signs, the investigating officer signs the statements of the witnesses. And based on the statements of the witnesses, he will prepare a report which is called the charge sheet, and he will file the charge sheet in the court. And after the charge sheet, trial starts. So this is the brief summary about how a criminal trial happens in India. Now you gave a complaint against 4 accused. That is, the complainant gave a complaint against the 4 accused. But because of some corruption or the known acquaintance of the police officer with one of the accused, only 3 accused came in the charge sheet. Police officer wantedly omitted the name of the husband's sister for some reasons, for personal reasons or some XYZ reasons. He decided not to include the name of the sister of the husband. But the name of the sister of the husband is in the FIR. But her name is missing in the charge sheet. So now court has power, the magistrate has power to include her name in the accused list also. For that, the complainant has to enter the witness box and inform the court under section 319 CrPC. Based on that application filed by the complainant and from the statements of the witnesses also. Now the statement of the witnesses are written by the police officer. He may omit it in the statements. But when the witnesses enter the witness box and orally inform the court that there are 4 accused in accordance with the FIR, then based on the examination, that will be called the examination in chief in the legal language. Based on the examination in chief of the witness, based on the examination in chief of the complainant, and based on the complaint of the complainant, and based on the FIR of the complainant, the accused whose name was removed in the charge sheet will be added in the charge sheet by the Honorable Court. So the court has absolute power. Here we must not worry when giving a complaint and suspect the investigation. Let them investigate in whatever way they want. They are at liberty. Even court does not interfere with their investigation because court knows that it has absolute and ultimate power to meet the ends of justice. So therefore, what we can learn from this decision, I have given the decision of the Honorable Supreme Court in the description, kindly go through it. Give a complaint properly. Include all the names in the FIR. Give a detailed complaint. I have made another video about how to write an effective police complaint, the art of writing a police complaint. Kindly go through that. I will, if possible, I will leave it in the iCards above. So give a complaint in detail, properly, including the names of all the accused, the date, time of the incident, in detail. A detailed complaint only enjoys the investigation. Otherwise, police officer will kill the investigation based on the complaint. And whenever you give a complaint, police officer tries to alter it based on your ignorance. Never try to alter the police complaint, even though it is not having sufficient evidence to carry for investigation. Give it as it is in the first person. Inform to the court whatever you saw with your eyes and ears. If police officer tries to interfere with the complaint, tries to threaten you that if it is modified only it will be registered as an FIR, then send the complaint by post, send the complaint by post to the SP, to the SHO, and then go to the police station, or send the complaint by email. So there are many remedies. Don't alter the nature of the complaint. So whatever is written in the complaint will come in the FIR. So your job is only to give the detailed information to the police. Give them information and leave the fate of the investigation at their mercy. Let them do it. Ultimately it comes to the court. Court will handle how to bring all the accused and serve the ends of justice. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.